Okay.
Oh, now Susan, you show up as Becky.
Quick question. I'm just, I'm just taking the CLE. I need to stop the video, right?
That part is up to you. I actually didn't even think that we were going to have video of everyone.
I will make sure everyone's video is off.
Okay.
Okay, so I'll turn mine off. Oh, you did it. Okay, thank you.
Yep.
And then I'm gonna mute myself.
Okay. All right. So Susan, it looks like we do have one more person in the waiting room.
I will let them in.
Can do that. Or, well, can I do that too?
You can.
Sorry. I'll do that if I see somebody else come up.
But we're all set. Ready to go.
Okay, great. All right, thank you. Welcome, everybody. Thanks for joining us here on this Thursday. So we have a great presentation set up for you. I'm going to give you a little bit of CLE background, housekeeping items, and then go ahead and introduce Deborah Dahlman to join us today. So if you did register for CLE credit, please know that you do need to watch it from your computer today, as opposed to just listening on your phone. You cannot get credit that way. After the presentation, a survey will be sent to you via email, so please be sure to complete that in order to receive your credit. At the bottom, I think everybody's kind of used to Zoom at this point, but at the bottom there is a chat function, and you are welcome to put your questions in there. We will address those at the end unless there's something pressing during the presentation that needs to be answered right then. So I'm going to go ahead and introduce you today to Deborah Dahlman, who has graciously agreed to join us and give us this great presentation on the overview of veterans benefits, VA character and discharge determination, and military discharge upgrades. A little bit of background I'd like to give you first about Deborah Dahlman. She is currently with the Legal Aid Society of Cleveland for the past 12 years. She's licensed to practice law in Virginia and Ohio, and is also accredited to practice before the Veterans Administration, which is something we're hoping to get into place for all of the attorneys who do volunteer with our program. Deborah is a senior staff attorney with the Legal Aid Society and is a member of the Legal Aid's Health and Opportunity Practice Group. So she focuses mainly on representing low-income individuals in various practice areas, including veterans benefits, Social Security child disability benefits, Medicaid and Medicare, and Ohio public benefits programs such as SNAP and cash assistance. Her veterans practice has focused on assisting veterans with less than honorable discharges, obtain VA benefits, and veterans who have incurred VA benefit overpayment. So in addition to her direct representation of the clients at Legal Aid, Deborah is also co-chair of Legal Aid's Disabilities Committee, which is dedicated to ensuring that people with disabilities have access to public benefits and community services through education, outreach, and advocacy. So Deborah, I'm going to go ahead and turn it over to you, and thank you for presenting today.
All right. Thank you, Katie, and thank you to the Bar Association for inviting me. And I think this Veterans Legal Service Clinic is going to be invaluable to the veterans community. And as Katie said, I'm with Legal Aid. I've been there for about 12 years, and but pre-law school, pre-Legal Aid, I worked for the Department of the Air Force. I didn't have military service. I was a civil servant. And I saw firsthand the dedication and sacrifices that are made by many of our service members. So at Legal Aid, when I was given the opportunity to represent veterans clients, I jumped at the chance. Our practice is somewhat limited. And even though I'm including a overview of veteran service compensation benefits, we don't assist clients in those claims. So as I said, it's going to be a very brief overview on that process. So when I was thinking about how I get across to you today, why a good portion of my presentation is important, I thought about my first my first veteran client, and I'll call him Mr. Smith. So Mr. Smith was a veteran, Vietnam veteran. He's in his 70s. He had an other than honorable discharge from the Army. And I picture him as a fiery, redheaded teen, 17 years old, growing up in San Francisco. He admittedly dabbled with LSD, which I guess everybody back in the 60s did in San Francisco. I'm not sure. But he decided to enlist in the Army to make something of himself. Fast forward 2 years into his enlistment, and he had actually done pretty well. He goes to the base hospital because of anxiety. And it turns out he was actually having flashbacks from his pre-service LSD use. The military labeled him as a habitual drug user, said he had an insatiable appetite for drugs, and despite no evidence of drug use in his record. He ends up with an other than honorable discharge, which means he does not or did not have access to VA benefits. And 50 years later, he's sitting in my office and I asked him what he wanted. And he said he wanted a discharge upgrade because, you know, he was proud of his military service. But I assessed his case and I agreed to represent him to try to get a VA pension benefit. So I did my best. I wrote a 10-page brief and argued everything I could think of to the VA. And so I went to his house, had him sign the documents, and by that time he was terminally ill, and he thanked me and he said, "No one has ever really fought for me before." So he really touched me. Unfortunately, we lost. The VA rubber stamped the Army's discharge, and then Mr. Smith died. I talked to his widow about filing an appeal, and she said to me, and she said, all he ever wanted was someone to believe in him. So I think that his story for me sums up why the last portion of this presentation is really important. We need to understand that sometimes the military discharge process is not necessarily fair. It doesn't take into consideration the mental health issues like PTSD and TPI, which may actually lead to the conduct that is the underlying factor in the discharge. So veterans advocates around the country are bringing this issue to the forefront. So I thought it was good information for everybody who's going to volunteer with the Legal Service Veterans Clinic to understand some of the obstacles that service members might face. So I almost forgot to change my slides. There we go. So that's kind of the intro. So the overview of VA benefits today will focus mainly on the VA pension, VA aid and attendance, just a brief overview of service connected, and some mentioning of other VA benefits. So with the VA, if a veteran has an honorable discharge, honorable or general discharge, they may be eligible for 2 disability benefit programs. The service connected and then the VA pension. And a lot of people aren't aware of the VA pension benefit, but it is actually a needs-based program similar to SSI for low-income wartime veterans. And to be eligible for a pension, you have to be considered to be permanently and totally disabled. If you're over 65, you're presumed by the VA to be disabled, which I wonder about that, but you can be in a long-term care facility. You get Social Security disability or SSI, or the VA can actually make a finding of permanent and total disability. You have to have 24 months of active duty service. Sorry for my screen. Active duty service, and there's no service connection, meaning your disability does not have to be connected to your prior service. And you have to have at least 1 day in an eligible wartime period. Wartime periods right now are these various periods, which I think we're all familiar with: World War I, World War II. Significantly, though, we are considered to have been in a wartime period since the Gulf War in 1990. So anyone that's serving right now is actually serving in a wartime period. For the VA pension benefits, you have to have an other than dishonorable discharge. And your income and assets do affect eligibility because this program focuses on low income veterans. In 2021, the maximum pension rate for a single veteran would be $11.60 a month. And the VA does apply asset tests, like you can't have two homes, you can't own a vacation home, which if you're low income, you likely don't. But the asset test is pretty generous. It's 130,000. There are exclusions like a home, the car that you use primarily for transportation. Unreimbursed medical expenses are deducted from income. So when a veteran comes to legal aid and I look at whether what income they're receiving, for instance, right now, if someone is only receiving SSI, the maximum monthly SSI is $794 a month. So if the person is eligible, they could actually have a pension from the VA of $11.60. But say, for instance, maybe the person gets Social Security disability, which might pay a higher rate, say around $1,200, then that person would not be financially eligible for a pension. But I think this is a benefit that a lot of people don't understand, but it is really helpful for low income veterans. And the next benefit, I am pretty sure that a lot of people aren't aware of this. This is actually an improved pension benefit called VA aid and attendance and housebound benefits. If you're eligible for aid and attendance, there's an increase in your pension benefit, and you have to show that you need another person to help you perform activities of daily living, or you have to stay in bed because of a disability, you're a patient in a nursing home. And I know for a while that the VA was actually doing presentations at nursing homes to make veterans aware of this benefit. It's important too that if you're a widow of a veteran, that you could be eligible for this benefit as well. So you could have, you know, a wife, husband with a veteran, now she's in a nursing home. This could be a good benefit to help to pay long-term care cost. So the difference of a regular pension and the aid and attendance, I can't do math that quickly, but you can see that if you're a surviving spouse, the pension would be $778. But if you were eligible for aid and attendance, the amount payable would be $1244 a month. So it does help for people who do have disabilities and incurring long-term care costs or need assistance. The housebound benefit, the requirement is that you spend most of your time in your home because of a disability, and the rate is less than the aid and attendance rate, but I really couldn't find any information of what the 2021 rate is. And quite frankly, I struggle sometimes to understand the difference between housebound and aid and attendance, because if your disability requires you to stay at home or you're housebound, then surely your activities of daily living are limited as well. How do you apply for the aid and attendance? There's an application form, and it's called the examination of housebound status or permanent need. And on the form, the veteran or surviving spouse completes it. And there's also a section on a form that you need to get a doctor to complete. Even though the form is available and must be submitted, I suggest that it's always best to include additional medical documentation, because with the VA, the more evidence you submit, the better. And so then the other disability benefit is the service-connected compensation. And basically the veteran has to show that he has a current disability, either physical or mental health, and evidence of an in-service occurrence or aggravation. And there has to be a nexus. And that means that the veteran has to show an existing injury, existing disease, basically that occurred in service or and that the disability was not a result of willful misconduct or drug abuse. And sometimes the nexus requirement can be the most difficult element to prove. And this service-connected compensation differs from the pension because income and assets do not affect whether you're eligible for this. And here's the 2020 pay rates for service connected. Basically what the VA does is they'll assign a percentage to the severity of your disability, which is a mystery to me how they do that. But you can see that the rates considerably increase the higher your disability is rated. And that is probably the extent of my knowledge on the service connected, but it's an important benefit for veterans, but it's pretty complex. And I'm sorry, I think my slide, there we go. So I just provided a couple of examples of possible how you would analyze whether the veteran would benefit from pension or service connected. Say 66-year-old car accident in service, had some injuries, but their evidence he was intoxicated. Nonetheless, he received a general discharge. So you think, okay, pension or service connected. Pension probably, because he's 66, he's presumed to be disabled. You think about the back injuries, that's his current disability. Would he be able to show that there's a nexus between the in-service accident? Would there be a question about whether he was intoxicated and was that willful misconduct? The next example actually is something that I've seen quite a bit. We have had quite a few veterans or service members come to us who had schizophrenia, and there was evidence in the record where in service that they actually had the onset of schizophrenia, which typically occurs in males in their late teens, early 20s. In my example, a veteran's homeless, he receives SSI, so that would be a good case for pension. The service connected might be difficult to prove, especially if there's nothing in the records that shows in-service treatment for schizophrenia. But I always try to look at what would benefit our clients the most, and a lot of times it's the pension. So other VA benefits, everybody's probably heard of the GI Bill and education benefits, home loans, the VA guarantees a portion of the loan. There's burial benefits, housing assistance. We have a lot of clients who are eligible for the HUD-VASH housing assistance, VA healthcare. Everybody most certainly knows that veterans are eligible for healthcare, but veterans with other than honorable discharges, previously their accessibility to healthcare was somewhat limited. More recently, there's been movement to recognize that even though you weren't discharged from the service honorably, that the VA will provide some treatment, and that's pretty much limited to service members who are in crisis with mental health conditions. They can receive treatment for 90 days, and under other conditions, they could receive treatment for 100 days. But the Veterans Health Administration will ask the Veterans Benefit Administration to look at the discharge and make a determination. And VA says that if the determination of their character of service isn't favorable, that the veteran can actually be billed for services. So that's kind of all I had on just the overview of some of the veterans benefits. I think it's important to understand what is available. So I included this slide because I think we all kind of say, you know, someone who served in the military, they're a veteran, but for VA purposes and for determining whether a person is eligible, the VA defines a veteran as who's someone who has served in the military and who was discharged or released under conditions other than dishonorable. So what that means is that the VA can look at the member's discharge, and under certain circumstances, they can make their own determination. If a veteran is discharged honorably or has a general discharge, then the VA, then that's honorable for VA purposes, meaning there's no question that that service member is eligible for VA benefits. If the service member is discharged with an other than honorable discharge, then the VA will make their own determination on whether that service is honorable for VA purposes. Same with bad conduct or a dishonorable discharge. They actually have to review the military records and make their own determination. And so, which means presumptively, people who have served and got an other than honorable bad conduct or dishonorable discharge are not eligible for VA benefits. So for those who aren't familiar, I know there's probably some former military members in the audience, but I pulled up tried to find a DD-214, which is the document that a service member gets when they separate from the military. And I was actually surprised to find that Elvis Presley's DD-214 was online. So you can see that Mr. Presley here received an honorable discharge, which means he would have been able to apply for VA benefits. And here's an example. I'm sorry, this is so small. A veteran who received a bad conduct discharge from the Air Force as a result of a court-martial. So this veteran would not be eligible for VA benefits. Presumptively not eligible for VA benefits. So in this case, with the gentleman with a bad conduct discharge, I'm sorry, I think the slide is a little bit out of order, but these two articles are actually really good background reading on the issue that I'm talking about, which is when veterans do not receive an honorable discharge, how the VA can and does not deny those veterans benefits. And I'm sorry, it should have been at the end. But so for when a veteran does not receive an honorable or general discharge, what are their options? And their options are twofold. Character of discharge, and that's an application to the VA, asking the VA, review my military records and make your own determination of the character of my service. For VA purposes, determine whether my service was honorable and determine whether I'm eligible. The other option is a military discharge upgrade. So the VA character of discharge process, basically in 1944, when Congress passed what is known as the GI Bill, what Congress said is that, or they actually intended to make VA benefits eligible for service members who did have some misconduct. And they said that VA can give benefits to those who with an other than dishonorable discharge. Since then, the VA has promulgated a series of kind of vague and confusing rules and decided that they can make their own determination. And what they decide is whether the member's service is honorable for VA purposes. And how do you apply, or how do you get this determination, is you can apply for any VA benefit, and it automatically triggers the VA's review of your military service. They'll pull the DD-214, they'll see that the member was discharged with an other than honorable discharge, and they'll send the member out a letter that says, hey, give me some information, and they'll make a determination. But under the VA character of discharge rules, there are regulatory and statutory bars, which we'll kind of go over. And the statutory bars basically are, under these conditions, they're not eligible at all for VA benefits. Conscientious objector, someone who has a dishonorable or a bad conduct discharge as a result of a general court-martial, an officer resigning for the good of the service, desertion, and someone that's discharged because of being AWOL for 180 days. So the only discretion that the VA has under these statutory bars is the AWOL. And if it's for a continuous period of 180 days, the VA has to look at whether there's compelling circumstances. They consider the length of service, family emergency, obligations or duties owed to third parties, and just basically the circumstances. I had a client who I think he was gone for over 180 days, and he initially told me that, well, his grandmother had died, he couldn't get leave, and so he just left. But I don't know why he stayed 180 days. I'm not sure that would be compelling circumstances. Let me see. One other thing about the compelling circumstances for 180 days, the VA adjudicators are specifically directed to look at hardship or suffering after an overseas service. So a veteran was deployed, they come back, maybe they're suffering from PTSD or traumatic brain injury. They just might decide they need to leave. And so the VA adjudicators are supposed to look at that. So I was going to explore, okay, so the next set of rules in the character of discharge regulations address what is called regulatory bars. Now, under these regulations, these circumstances are not a complete bar to benefits, but the veteran has to argue why there's an exception, why this doesn't apply. The VA does have discretion to consider discretion or underlying facts and circumstances. And these regulatory bars are whether the member was accepted an undesirable discharge to escape a trial by general court-martial, and mutiny or spying. I don't think that's very often. Offense involving moral turpitude, which is most definitely open to interpretation, and probably the most, I want to say litigated, but the most, the area that sees the most decisions is willful and persistent misconduct. And the other regulatory bar is homosexual acts involving aggravating circumstances. There are proposed rule changes right now that the VA is considering, and the proposed change to this section is to change homosexual to sexual acts. So as I said, like the VA character of discharge process and some of the rules are pretty vague. The VA really hasn't defined some of these terms. They do say that willful and persistent conduct, a discharge because of a minor offense, will not be considered willful or persistent if the rest of the service was otherwise honest, faithful, and meritorious. Willful, these are regulations that actually are in the service-connected portion of the regulations. Here, mere technical violations is not considered willful, and not willful if it's isolated infrequent drug use. And that's what I thought with my client, even if assuming that there was drug use, it was one time, so it wouldn't be willful and persistent, and he wasn't taking drugs to the point of addiction. But all these terms that the VA uses are really poorly defined. And persistent, again, is not defined in the character of discharge regulations, but the VA adjudicators manual at at this section here does say that multiple offenses are not automatically deemed persistent. Minor offenses, again, here's AWOL greater than 30 days is not minor. So maybe if you had a veteran that had 10 days without leave, then you could argue that was a minor offense. What does otherwise honest, faithful, and meritorious mean? You would bring up the awards, conduct prior to the incident giving rise to the discharge, performance marks, evaluations. And I've seen briefs and legal argument that actually break down the period of service. Say the service member has been in for 3 years, the incident occurred 2.5 years into service, and you could argue the veteran has 600 days of good service, and therefore his service overall was honest, faithful, and meritorious. Moral turpitude, again, not defined. There are several VA Office of General Counsel presidential opinions that try to define or at least shed some light on what moral turpitude is. Most importantly, in the VA Adjudicator's Manual, when the character of discharge decisions are made, the adjudicator at the regional offices are directed to apply a liberal standard and to consider the context and mitigating circumstances. And I think this is specifically applied when the veteran is arguing that there was a mental condition or physical condition that resulted in the offense. And one of the most important things, adjudicators at the regional offices are directed, this is actually a quote from the manual. It says, occasionally service departments provide only limited records. In my experience, I don't think it's occasionally. I think a lot of times the member's military personnel file doesn't contain a lot of information. So the adjudicators are to make a determination using all the evidence and resolve any reasonable doubt in favor of the claimant. I'm not so sure how well the adjudicators are really applying this, but reasonable doubt is supposed to be given to the veteran. So less common is the regulatory bar of accepting an undesirable discharge. Sometimes the DD 214 will just say in lieu of court-martial for good of the service, and it's important to check. Maybe it's contained in the records whether it was actually a general court-martial. General court-martial is like felony, and it could be that a special or summary court-martial was proposed. So you would need to clarify that. So, or an exception to the regulatory and statutory bars is called the insanity exception. And so if there are these bars that exist in the veteran's case, the VA says these apply unless he's insane. But the VA's definition of insanity is not the same as what we commonly know. It's not the criminal definition of insanity of knowing right from wrong or the consequences of the action. The definition of insanity for VA purposes is, while not mentally defective or constitutionally psychopathic, I really haven't figured that out, but due to a disease, the veteran would exhibit prolonged deviation from his normal method of behavior, interferes with the peace of society, not quite sure what that means, or has so departed, became antisocial from the accepted standards of the community. Sadly, how does the VA apply the insanity exception? Pretty inconsistently. I made sure a few days ago that I went back to the VA Adjudicator's Manual just to see if there was any more specific direction to the VA adjudicators. And there really isn't. The only direction is that the adjudicators are supposed to develop the case completely, which means if there is evidence that the veteran was suffering from a mental health condition, such as PTSD or TPI, that the adjudicators are supposed to obtain all the documents, post-service treatment records, and transcripts of any court martial or board proceedings. I haven't looked at this case, Zhang v. Brown, for a while, but it's cited most often for its observation that the definition of insanity is less than clear, and it really is. So it is, I'm sorry, I think the slides are going all the way to the bottom. And it is recommended that if the veteran is trying to show or prove that he was insane during the time of the offense, that they submit a medical opinion. It can be by a VA doctor, which basically there's not much of a chance that the veteran is actually receiving VA healthcare treatment, but that it's recommended that the veteran submit a doctor's opinion that the veteran is insane, as that term is used by the VA. So to apply for a character of discharge, again, the character of discharge determination is triggered anytime a veteran applies for any VA benefit. The determination, it should be automatic. There's no separate character of discharge application process or form. The decisions are made at the VA regional offices, and the success rate of these determinations actually varies by, between regional offices. Some of them are better than others. I'm not sure where Cleveland stands right now. Importantly, the veteran is entitled to a hearing on the issue of character of discharge, and you can simply do that on a statement to support a claim and write, I request a hearing on the issue of my character of discharge. You can include a legal brief, which is what I did in my veterans case, statements of friends, buddy statements, but again, most importantly, medical opinions, medical treatment records if you're arguing the insanity. The character of discharge determinations made by the regional offices can be appealed to the Board of Veterans Appeals and the Court of Appeals for Veterans Claims. If a determination is made at the regional office, you can file a notice of a disagreement within a year. To have the regional office reopen that claim, you have to submit new and material evidence. And the reason why sometimes if the veteran is not alleging a service-connected claim, and I'm looking at whether they're eligible for pension, the reason why I generally recommend that this be the first step is that it's quicker than a discharge upgrade. But it's important for veterans to know that a character of discharge determination by the VA in no way changes their DD-214. So they're not gonna see that they're not gonna be issued a new DD-214 that says that they have a general discharge other than honorable discharge. And sometimes really that's what veterans want. But this VA determination might be a quicker way than a discharge upgrade. Okay. Conclusion, I think I probably said this throughout, is the character of determination, character of discharge determination is confusing at best. And I think that service members actually need help with this process, although the VA says that service members can navigate this. But the thinking by most advocates is that the veterans or service members really need to know how to speak the VA language, and they're really not aware. I've seen the VA send out a document after an initial application saying, hey, we got your application, please submit additional evidence, and then they'll send 2 pages of the regulations. but it's best if veteran does understand that he needs to say, my conduct was not willful and persistent, and I'm insane, instead of saying, yeah, the Air Force promised me that I would be military police and I wasn't. Or I think that a more successful application will be written with the VA terms and arguments around that. And definitely if mental health contributed, that the veteran should argue insanity. So the other avenue for service members who do not have an honorable or general discharge is to apply for actual discharge upgrade. And that's an upgrade they'll be issued a new DD-14, perhaps have an other than honorable discharge, upgrade it to a general discharge, for instance. And the two avenues for that are the discharge review boards and the Board for Correction of Military Records. And I have to say, caveat here again, in 4 years, I've probably had one case that I thought was factually good to submit to, I think it was the Air Force Discharge Review Board, but unfortunately, clients come and go. My client had a substance abuse problem, and so I wasn't able to go forward with that. But I'll present for you today just an overview of the process. So each service branch has their own discharge review board. There is a 15-year statute of limitations, meaning from the date of discharge, the service member has 15 years to apply for an upgrade with the discharge review board. The board specializing in upgrading the discharges, and they can make changes to the narrative that's on service members DD-214, like removing homosexuality from the DD-214, or maybe the narrative says drug use, and maybe a service member would want to get that changed. So the boards can do that. Service members who were dismissed by general court-martial, a conviction of general court-martial, which is again like a felony conviction, they cannot apply for a discharge upgrade through the discharge review boards. The success rate varies depending on the service branch. I tried to find statistics. I couldn't find those, but I think there have been some changes where maybe the boards are reviewing claims based on, again, the mental health conditions, TBI, PTSD. I think there is movement where maybe the success rates that are based on those claims might be better. So just briefly, the standard of review for these boards, it's in 32 CFR Part 70. The standard of review is propriety and equity. Propriety is like if there's an error in fact and law or prejudice, and equity is the principles of equity that we kind of come to understand and know. This wasn't fair. Maybe there was a change in policies or procedures that would have affected whether this member got other than honorable discharge. If a discharge is based on a court-martial, again, the member will only be granted an upgrade based on clemency, because the discharge review boards cannot set aside a conviction issued by a general or special court-martial. There's two ways for the discharge review boards for your application or your proceeding to. There's two ways to get before the military discharge review board. You can request just a records review, or you can actually request a personal hearing, which, unless there's a traveling board in your area, the personal hearing would be in Washington, DC. So as I said, first, there's a records review you can request. And then if you request a records review initially, and if you're denied, you can apply for a personal hearing. So you kind of have two bites at the apple, but the board, of course, would have, the information and everything, and the decisional documents from the records review. After you can appeal a discharge review board decision to federal court. So the other mechanism with the military branches to request an upgrade is the Board of Correction of Military Records, BCMRs. Again, each service branch has their own BCMR. There is a 3-year time limit, which is waivable, but it's not 3 years from the date of discharge. It's 3 years from the date of discovering the error or injustice. So the statute says that the 3-year time limit may be waived if it is in the interest of justice to do so. The Board of Corrections for Military Records can upgrade discharges issued by general court martials, unlike the DRBs. So the DRBs, or the Board of Corrections for Military Records, they can change errors, like errors on your D-214, re-enlistment codes, errors in your personnel records. And those are things that the discharge review boards can't do. So if a service member has the option of applying to either the discharge review board or the BCMR requires the member to apply to the DRB first. Again, discharge is issued as a result of a conviction by a special or general court martial, can only be upgraded on clemency grounds. The standard of review for these boards is to correct an injustice or error. And I didn't put a citation there because, quite honestly, the board's guidance in CFR, there's actually more than there is for the Board of Corrections for Military Records. There is a special, and I don't know how new this is, but I feel like it's pretty recent because of the movement for boards and the VA to consider the mental health of the veterans. There's a section that states that the board shall review claims with liberal consideration when there's evidence that there's PTSD or TPI, or the person is actually claiming that the circumstances were attributable to mental health. So actually that's a good development. Application process to the DRB, DD Form 293, BCMR, DD Form 149. And I actually pulled those this morning just to refresh my memory. And they're really very simple, but there's actually a very small amount of space for the veteran to say, you know, I want this to charge because of X. So that's the reason why I put, you know, applicants increase their chances by submitting a brief, again, just like in the VA character of discharge process, speak the board's language, you know, emphasize favorable aspects of military service, highlight anything that mitigates, and explain why an upgrade should be given. Statement of material contentions, statement of the veteran, sworn or notarized if possible, and evidence of in-service conduct, including witness statements, there again, buddy statements, and good performance reviews. So basically you want to emphasize anything that was good and anything that might mitigate against the discharge. So most importantly, when requesting clemency, the boards actually are interested in post-service conduct. So it's important, if possible. Actually, when I had a client who I was considering, you know, working up a military discharge upgrade, I consulted with one of the attorneys that I know with another legal aid program who does this regularly. And she said to me, has your client rescued anybody from a burning building lately? And I said, no. And so it's almost like the more time that goes by, the more time that the veteran or service member can build up a good post-service record, the better, even though the veteran is very anxious about having his discharge upgraded. So character references, letters from employment, education documents, police clearance showing no criminal involvement, awards, evidence of involvement in charitable or civic activities. And that's particularly important in punitive discharge cases like bad conduct discharge. I did want to highlight that, like I said, in recent years, the Department of Defense, there's been a movement to make sure that the boards actually do actively consider PTSD, TPI, military sexual trauma, and the effect that that can have on a member's conduct while in service. There are actually some statistics, some good studies shown. 2016, NPR reported that between 2009 and 2015, in the Army alone, there was separation of 22,000 combat soldiers for misconduct, even after they received diagnosis for mental health problems. So, the issue is, the service member is suffering from TPI or PTSD, but still some of the convening authorities and military branches don't consider what relationship that mental health condition may have on a member's conduct while in service. And in fact, PTSD, this is especially harsh for Vietnam veterans because PTSD was not even a diagnosis until 1980. So Vietnam veterans were especially vulnerable to being discharged with an unfavorable or bad conduct or other than honorable discharge without any consideration of the effects of mental health may have had. There's reference here to this May 27 GAO report, which I downloaded. It has lots of charts and graphs, and they got a lot of information from the different military branches. So the reference to the Hagel, Kurta, Wilkie, and Carson memos, it's a string of memos. Secretary of Defense, Hagel, Kurta, Carson, I think he was Secretary of Defense, Wilkie, Secretary of the VA. Basically, it was a direction for the boards to affirmatively look at when a member is alleging that he suffered from PTSD, military sexual trauma, TPI, or other mental health conditions, and actually look at how those conditions or symptoms of those conditions may have attributed to the conduct that gave rise to the discharge. The memos, I think it's in the Hagel memo, there's some language in there where they're trying to recognize the invisible wounds of these conditions. So, and affirmatively, veterans whose applications were previously denied can reapply, and the boards are required to make an entirely new decision and not consider any past rejection when reviewing the application. So this is a really good development in the discharge upgrade processes. I was going to do case examples, but I see I don't have minutes left. So did we want to have any questions? Well, I do have, I should cover this slide. As Katie mentioned, as we move forward with the Veterans Legal Services Clinic, there is an accreditation process for representatives through the VA. You can find an accredited representative at this website, and the instructions on how to become accredited through the VA are with the basically the Office of General Counsel for the VA. The application process is not that difficult. Military records, to get a service member's military records, you have to request them from the National Personnel Records Center, although unfortunately, everybody, I think a lot of people are aware, in 1973, there was a big fire. Records of some service members were destroyed. You might want to sometimes request court-martial transcripts, and so I've provided information regarding that. And here's some additional helpful resources, or at least resources that I found particularly informative and helpful. So I think that's it.
Great. Thank you, Deb. So we do have at least one question so far.
Oh, okay.
Can VA representatives file an application for a veteran online? Does it all have to be on paper?
I want to say yes, but I have to say I'm not sure. The VA has changes to some of their websites, so You know, I can look and provide you with an answer, Katie. If it's like Social Security, I would imagine for VA pension, there may be an application, but service connected, it's so involved.
Okay.
Yeah, I can jot down and send you a link, Katie.
Okay. Yeah, that would be great. And we can certainly share that with
Yeah.
everybody. And just going back a couple slides, you had that information about the VA accreditation.
Yeah.
So in the process for that, it sounds like it's completing a form and then you have to do certain CLEs through the VA. Is that accurate? Do you know?
What it is you submit a form. I think you have to submit certificate of good standing, maybe even something from your law school, which, you know, for a lot of us was a time ago.
Right.
Yeah, you do get accreditation right away, but within, I want to say it's a year or 2 year period, you have to complete 3 credits of veteran specific CLE programs. And I know PLI has, Practicing Law Institute has a really good set of veterans benefits CLEs, which the VA Office of General Counsel has said, you know, meets this requirement.
Okay. Okay. Just
Best to
meeting.
go ahead and look at that website because it's been a little while since I did the process, but I believe it's within, you get your VA accreditation, but within a certain period of time, you have to complete the CLEs. And then you have to have 3 CLEs every 2 years. You report every 2 years, I believe it is.
Okay. And is there a fee at all associated with that?
See, for me, I don't remember because legal
Okay.
aid probably would have paid the fee.
Right. Right.
I'm gonna check
Okay.
this site again.
Sure, will do. Does anybody else have any more questions that they want to put in the chat or even just unmute yourself and ask anything? All right, well, thank you, Deborah. This was so informative. I don't have
I
a
hope
large
so.
background in veterans benefits and I learned an awful lot today. So
Well, I hope so. I'm
really
out of breath.
appreciate that.
I'm out of breath. I wanted
Yeah,
to get through my 46 slides.
And you did it, so thank you.
No, but if
you were
anybody
great.
has questions, you know, please feel free to reach out.
Okay.
Thank you
for
very
being a
much,
resource
Katie.
for us. And so if everybody, if you could just watch your email, you will receive an email. Dominica Essie will be sending that out from our office. Just please go ahead and complete that so you can go ahead and get your CLE credit for that. And just watch your email and the CMBA website. We hope to have an additional CLE taking place in March for veterans volunteers here. And one in April, hopefully on the Veterans Treatment Court. So, or that will be one of the ones upcoming. So, so thanks for joining us today and have a great weekend. Bye.
Thank you.
Okay, thank you, Deborah.
Mhm.